Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal educational content, and today will be the day I earn that subscription. For today's story, we turn our attention to the court I know and love the best, the United States Supreme Court, a court where we need to understand many things that happen, and we need to understand the law. So today we turn our attention to that case. Okay. All right. So what's happening in this case? Let's talk about this. All right. A guy in Georgia was convicted of a charge and also acquitted of a charge. The judge, the Court of Appeals, and the Supreme Court found that these verdicts by the jury were mutually inconsistent. And that's a thing that can certainly happen. And I'll give you an example outside this case just to help illustrate the point, because I think it might be better to understand it. So an example where this would occur, this is not this case, but just generally would be felony murder. Felony murder is when a death occurs during an otherwise dangerous felony. So the intent isn't to kill, the intent is to create the dangerous situation from an inherently dangerous felony. An example of which might be, for example, an armed robbery of a convenience store. You know, you bring a gun, or one of your co-conspirators brings a gun, even if you didn't know they had it. The hand of one is the hand of all. That's conspiracies. Don't join conspiracies. And you or your co-confederate, who you didn't even know had a gun, breaks out the gun to threaten the clerk, and the clerk, or perhaps some, person who just happens to be there with a concealed weapon, takes action and fires and hits somebody, one of your co-conspirators, or perhaps an innocent even by mistake. Okay, well, guess what? You're guilty of felony murder because you created the inherently dangerous situation. You created the violent felony, and it was foreseeable and reasonable that someone was going to act to protect themselves using deadly force because of what you did. And so you are responsible for that. Now, I should take note, however, that this is a relatively rare rule in the world. I believe there's only something like 3 or maybe 4 countries that have this rule, and none of them you've ever heard of before. Also in the United States, it's been controversial, especially in recent years. Legislatures to varying degrees have either limited it or gotten rid of it altogether to varying degrees. But I don't think it's a problem personally, in my humble opinion, because once again, you created the dangerous situation. You used violence. It was pretty foreseeable someone was going to create violence, and that violence is on you because you created the situations. So personally, I don't find it to be a problem, but that's just me. So what would an inherently contradictory verdict look like if you were charged with felony murder? Well, the jury has to find the underlying felony, because the whole premise of the thing is that you committed the underlying inherently dangerous felony, and a death occurred as a result of the inherently dangerous felony for which you're responsible. So a mutually inconsistent verdict would look something like the jury not finding the underlying felony, not guilty, but finding guilty the felony murder, right? So they return a verdict of not guilty for the underlying felony, but return a verdict of guilty for the felony murder on which it necessarily is predicated. So that would be an example of an inherently contradictory verdict, and you better believe that has absolutely happened before in law. Now, the U.S. Supreme Court, for its part, has said as a matter of federal law, they're not really bothered by the inherently inconsistent verdicts, because they say, for example, they're not sure where the mistake might have occurred, and they're willing to defer to the jury. So they're not bothered by the logical inconsistency. But of course, states, as a matter of their state law, could obviously disagree, right? That's just the federal rule. Different states can have their own rule. And Georgia, it seems, at least as it applies to this case, finds the mutual inconsistency can't survive. What was the mutual inconsistency in this case? Well, the guy was found guilty but mentally ill as to felony murder, but not guilty by reason of insanity as to malice murder. So he's both guilty with mental problems that doesn't negate his guilt as to felony murder, but not guilty by reason of insanity as to the malice murder with respect to him killing his mother, which seems inherently contradictory, right? You're dealing with the same exact incident, the murder of the woman, right? So the facts wouldn't change because they're two different murders. It's the same murder. So how can you simultaneously be guilty with some mental illness and also simultaneously not guilty by reason of insanity? How can both those things be true at the same time? The U.S. Supreme Court wouldn't care about that part. Georgia apparently does care. So the trial court said there wasn't a problem, but the Georgia Supreme Court said this is a problem. We can't tolerate these mutually inconsistent verdicts. Okay, well, at that point, the only logical solution consistent with the Constitution, which, as you may recall, forbids being twice put in jeopardy for the same incident, double jeopardy. The only way to resolve the tension at that point is to say, because they're inconsistent, this verdict cannot withstand as a matter of law. Because of a finding of the jury that reaches an inconsistency, the only way to resolve the tension is to issue a judgment that can't be survived as a matter of law, right? But that's not what Georgia Supreme Court did. They said, okay, the jury's verdicts are mutually inconsistent. Therefore, we're going to vacate the trial decision because the jury's verdicts are inconsistent. They're insufficiently reliable. And how about a new trial, despite the fact you were found not guilty before on that charge? Let's try again. Let's have another trial with another jury, and we'll ask them if you're guilty of the exact same charge for which the prior jury already found you not guilty, which sounds very suspiciously like being put twice in jeopardy for the same offense. But the Georgia Supreme Court disagrees, because after he went to trial and said double jeopardy, the trial court disagreed, the Court of Appeals disagreed, and Georgia Supreme Court disagreed. We don't see any double jeopardy problem here. No problem with that. What? That's not how this works. That's not how any of this works. The jury made a mistake, perhaps, but they made a mistake of acquittal. You can't reverse that, not for just a mistake or an inconsistency. Now that doesn't make sense. So Georgia apparently doesn't understand the law. Thus, the question to the United States Supreme Court, which somehow is a question, does the Jeopardy Clause of the Fifth Amendment prohibit a second prosecution for a crime of which the defendant was previously found not guilty? Yeah, it obviously does. If this isn't 9-0, I will be absolutely and truly amazed. But never mind. We have to focus on the law. So let's listen to the oral arguments and see, if somehow, some way, Georgia can convince me my legal analysis is wrong. I look forward to that. That should be fun and exciting. Great. All right. We turn our attention to the U.S. Supreme Court in the case of Damien McElrath versus Georgia, which was argued on the November 28th. We're going to listen to the oral arguments and see what it says. Let's get started with this.
We'll hear argument first this morning in case 22721, McElrath versus Georgia. Mr. Simpson?
Mr. Chief Justice, and may it please the Court, the most fundamental principle of double jeopardy law, going back hundreds of years before even the adoption of the Constitution, is that if a jury in a court with jurisdiction returns a verdict of acquittal, that verdict is final. The defendant may not be subjected to a second prosecution ever. No questions, end of discussion. This case is the paradigm in which that example applies, or that principle applies. Mr. McElrath went to trial before a jury in Georgia. The jury found him not guilty of malice murder by reason of insanity. No one has questioned that jury deliberated in accordance with Georgia processes. It returned a verdict in accordance with Georgia processes. The state and the defendant both affirmatively indicated they had no objection to the form of the verdict. The court accepted it and entered judgment. Accordingly, that is the end of it as far as the malice murder charge is concerned. The state contends that Mr. McElrath can be subjected to a second trial because that acquittal is repugnant to a conviction on separate offenses, and this Court's analysis has always been offense by offense. He was found guilty but mentally ill as to felony murder, and guilty but mentally ill as to aggravated assault. This repugnant verdict exception to the double jeopardy principle does not stand, cannot withstand analysis. The state really makes two arguments. The first is that this Court's inconsistent verdict cases do not apply because there's a difference between a repugnant verdict and an inconsistent verdict. And in particular, that with a repugnant verdict, there is no uncertainty as to what the jury did. That is wrong as a factual matter because the uncertainty is the same, but more importantly, it does not matter because an acquittal is final regardless. It does not matter.
Yeah, that's sort of the end of that game, right? So the Supreme Court has talked about innocent, mutually inconsistent verdicts, as I've discussed, with respect to a guilty verdict, in which case the Supreme Court tends to not care as a matter of federal law. But, so yeah, you can and must, well, you don't have to, you can reverse the guilty verdict because it's mutually inconsistent, but not the other way around. You can't switch the acquittal to a conviction or order a new trial. That's some bullshit.
Why the jury reached that conclusion, the acquittal is final and conclusive. I welcome the Court's questions.
So your client filed a motion to vacate the conviction as repugnant. What is the effect when a verdict is determined to be repugnant? What's the effect of that?
But this Court has held.
No, I mean the Georgia code.
In Georgia, before this case, and the Turner case in the Georgia Supreme Court is the leading example, the acquittal would stand and the conviction would be vacated. In this case, the Georgia Supreme Court, for the first time, held that both the acquittal and the conviction should be vacated.
I think if I understand the opinion below correctly, the Georgia Supreme Court says that because of the repugnancy, there was no verdict. And that's what I'm trying to understand. If with respect to your motion earlier, was it your goal, was the argument that the verdict was void because it was repugnant, or simply that it should be vacated because it was repugnant?
Our argument was that the conviction should be vacated. The conviction should be vacated because they were repugnant. Neither side in McElrath 1 raised any question about the acquittal standing. So on appeal, we argued to the Georgia Supreme Court, you should throw out the conviction. But neither side argued that the acquittal was in question.
Well, as a general matter, do you agree that it's a matter of state law when jeopardy terminates? Because that's the basic question, right? Whether the defendant is being put in jeopardy more than once. So you have to have the first jeopardy terminate before you can get to the question of whether or not he's in jeopardy a second time. As a general matter, is that a question of state law?
As a general matter, yes, Mr. Chief Justice, but
I don't quite understand the idea of jeopardy terminating. It suggests that Germany, I suppose, if you want to say that, jeopardy terminates when the trial is over, I suppose, at the moment the jury reaches its verdict of not guilty, because there's nothing to do, right? So if the jury finds guilty, at least hypothetically, at least in some states, the judge can say, not guilty, judgment notwithstanding the verdict, but obviously not the other way around. So judgment, I guess verdict would stop when the jury comes not guilty. Incidentally, by the way, the jury attaches the moment where you're in jeopardy, in case you care, is at a bench trial without a jury. Jeopardy attaches when the first witness is called, and when there is a jury, jeopardy attaches when the jury is sworn in. So that's the moment when jeopardy starts, just by way of legal analysis. Okay.
That is subject to this Court making the ultimate determination as to what constitutes an acquittal. This Court has held that jeopardy terminates when there is an acquittal. And so within broad ranges, the state has discretion subject to constitutional limitations, due process, speedy trial, et cetera, to set procedures.
What if one of the procedures is that the verdict form has to be signed by the jury foreman, okay? And the jury reaches a verdict, 12 to nothing or whatever, that the defendant is not guilty. But the jury foreman, as he's presenting the verdict or whatever, decides, I'm not, I have second thoughts. I'm not going to sign it. So as a matter of state law, is that verdict terminate the first jeopardy or not?
No, because the signing of the verdict is a procedural requirement, and the state is free to enforce that procedural requirement. The difference here, and the Georgia Supreme Court opinions acknowledge this, is that there was not one verdict. There were verdicts. No one questions there were verdicts. And to determine that verdict was void, the acquittal, the Georgia Supreme Court looked at the acquittal, looked at the conviction, compared the two after the fact, and concluded that they were repugnant and therefore declared them to be void.
So you would say the question before us is whether Georgia, as a matter of state law, can say that a verdict that jeopardy has not terminated until, for example, they determine that the verdicts are not repugnant. They draw a distinction between inconsistent verdicts, on which, of course, we already have established law, and repugnant verdicts. So, what if...
I'm not sure what the distinction is, incidentally, between inconsistent and repugnant. Georgia seems to think there's a difference. I'm not sure what that difference is. Maybe someone will explain to me at some point. Uki.
They have a system where once the jury has reached a verdict, it's not effective for a week to give the jurors a chance to ponder it a little bit more for whatever reason. When would jeopardy terminate in that case?
The issue there, Mr. Chief Justice, would focus on, I would say, due process in particular as to those procedures by which the verdict needed to be returned, what the state can't do.
Well, but what I asked about what the state did. Is that something they can do? In other words, say, yes, the jury has determined, not guilty, but under state law, that's not effective for another week.
That sounds like some bullshit.
No. Once
and in that interim, of course, the juror dies or...
I apologize. Once the verdict has been returned, this Court's cases, including Ball going back to 1896, would hold once the verdict has been returned, that's what terminates jeopardy.
Okay, so, let's say Georgia says that's not the verdict, that is the preliminary determination. So
that sounds like some bullshit too.
Court and announce here our preliminary.
Yeah, the law doesn't really like magic words. The label you put on the thing is not the thing. The thing is the thing. So you can't magically, a rose by any other name, basically, to make it easy, right? The law doesn't tend to look to what you call it, because we are well aware that you might try to say it's something else for whatever reason you want to say it's something else. The law looks to what it is. So you're like, oh, this is a preliminary determination, not a verdict. That's where I'm like, screw you. No, you can't just put magically a different label on it and say it's not the thing. It's the thing. The fact that you're trying to pretend it's not the thing is cute and all, but go away. That should be the right legal analysis. We don't really do magic words. It depends what it is.
Determination is unanimous that not guilty. And under Georgia law, that is a preliminary determination. It becomes the verdict after 1 week.
It would be, I believe, a due process question as to whether that procedure passes muster. The procedural aspects, the state has broad discretion. What they can't do is make a decision based on the content. So that
is that because it's a matter of federal law? I mean, I guess I don't understand your response to the Chief Justice's first question, which was, is this question of when something is an acquittal a matter of state law or federal law? And I had understood it to be a federal question, such that when we looked at double jeopardy in prior cases, I'm thinking about Bluford versus Arkansas, for example,
yes,
we evaluated it as a matter of federal law, correct?
Well, ultimately, this Court determines what constitutes an acquittal. So, for example, Bluford is an example of a case in which the jury failed to reach a verdict.
So no matter what label the state puts on it, if the state can have all kinds of procedures and it can say, well, we're going to say that this particular result is not an acquittal. we've held, I thought, that it's sort of a functional analysis and that as a matter of federal law, we look at what happened and determine what counts as a.
That sounds suspiciously like what I just said a moment ago. That sounds very suspiciously similar. Justice Jackson basically saying exactly what I just said just now. This is functional. We look to what it is. That's how we roll.
As an acquittal.
Exactly, Justice Jackson. In Smallest, this case, the Pennsylvania Supreme Court had characterized the granting of a demur as not an acquittal. This court held that it was an acquittal. Similarly, in Evans, Michigan had held that the ruling by the court in a case in which the judge mistakenly thought there was an additional element was not an acquittal. This court held it's an acquittal. The definition of acquittal, just last term, in the Smith case, this court defined what an acquittal is, and that is a determination, a resolution of criminal culpability.
Well, to pick up on that,
I'm sorry.
to pick up on that, Mr. Simpson, it's my understanding that there are jurisdictions in which the rule is that if a jury returns an inconsistent verdict or some subcategory of inconsistent verdict, the proper procedure for the trial judge is to instruct the jury, you can't do that. Your verdicts are irreconcilable. Go back and deliberate some more. Is that your understanding, too?
I'm not aware of a state that does that. Our position would be that would violate the double jeopardy clause, but of course you don't need to reach that here because the verdict was accepted. But
I believe I stand ready to be corrected if I'm wrong, but that's the rule in Missouri, Kansas, Arizona. So let's assume that that does not violate double jeopardy. If we were to hold that it does, then our decision here would have implications beyond Georgia. Assume that that is the rule.
Yes.
If that is the rule, then would it be a violation of double jeopardy for this to occur? The trial judge violates state law, accepts the inconsistent verdicts, and accepts the conviction on one count, acquittal on the other count. One of the parties says, no, you violated state law. There's an appeal. And the state Supreme Court says, no, this was a violation of state law. Go back and retry both counts.
Once the verdict...
Would you draw a distinction between those two situations?
I would draw a distinction, and I believe you're correct that Missouri does follow that process, or at least I've seen a case in which they did that. The difference would be that once the verdict has been accepted, then going up on appeal, it could not be challenged for much the same reasons that in the Evans case, notwithstanding that the judge quite explicitly based his decision on an element of the crime that didn't exist, this court nonetheless held that's binding once that verdict was accepted.
Well, that seems to make the rule that you're asking us for, pretty insignificant, right? If we come out of this case and it turns out that when the jury form is given to the judge can look at it and say, no, I don't think so. That looks inconsistent. That looks repugnant. Whatever word you want to put on it, go back and try it again. Then in the next case, the judge is just going to do that. And so this will be a one case only sort of ruling.
And Justice Kagan, that is not our position. Our position is that once the jury returns the verdict, that double jeopardy protection is triggered, that the jeopardy has ended. I wanted to make the point that there's a distinction. That's not what happened here, but we believe that once the jury has returned the verdict and there is an acquittal, that's the end of it. The judge may not send it back. Now, that doesn't have to be decided in this case.
Well, do you have you argue that a state can't take what's really an acquittal and put some other label on it and say, no, there wasn't an acquittal. But do you have any double jeopardy precedent from this court, or for that matter from lower federal courts, saying that a state cannot have a procedure like the Missouri procedure?
The repugnant
the state can't have a rule that says the trial judge is not to accept inconsistent verdicts or repugnant verdicts. That's a violation of double jeopardy.
I'm not aware of a case directly on point on that issue. The principle, I think, will be the same as raised here.
Another related question. This is my other point of concern about this case. You seem to agree in your reply brief, or at least you don't contest the proposition that if a jury returns inconsistent verdicts or repugnant verdicts on the same count, the double jeopardy clause.
Emily in chat asks, why do we have juries when it doesn't matter? Okay. So juries are to find facts. That's what juries are for, the finders of fact. The premise here is that the jury has found facts that can't exist at the same time, right? It can't be A and not A at the same time. It's like basic logical reasoning, right? So the jury found both A and not A. And so it's like, well, that doesn't make sense, jury, because you can't do both those things at the same time. Those are inconsistent or repugnant or whatever magical word we're putting on it, right? So we talk about the reasonably prudent person, right? We talk about the reasonably prudent person, the reasonably prudent juror, no reasonable jury, right? So yeah, the reasonably prudent person cannot believe A and not A at the same time. They can't find, as a matter of fact, both it did occur and didn't occur, right? That doesn't make sense. So this is where the law is trying to step in and be like, wait a second, the jury's decision doesn't make logical sense. It fails fundamental logical reasoning. No reasonable jury can do this, right? Now, the U.S. Supreme Court has said, as a matter of federal law, that we don't really care. You know, we're all about the mutually inconsistent. That's fine. We don't really care. But of course, other states could, as a matter of their state law, say we do care. So Georgia's allowed to care. Georgia's allowed to care that the inconsistency doesn't make sense. The question isn't that they're allowed to care. The question is, how can they resolve the tension? And given the double jeopardy provision of the Fifth Amendment, there's only one legal way to resolve the tension. The only legal way to represent the tension is by leveling down, right? So you have to level down because you level in favor of the defendant, because the defendant is presumed innocent. So if they're inconsistent, there's only one thing to do. You can't find that they should have found guilty on the one charge because double jeopardy. The only way to resolve it is to say, well, as a matter of law, the jury screwed up. The only way to resolve this as a matter of law is not guilty. Defendant wins. But Georgia went the other way. And there's like, okay, let's just have a new trial. It's like, no. Do I think it could have been avoided with better jury instructions? No, not really. No, because every charge has to be considered unto itself. And I'm not sure better instructions can really solve this problem. It's just like they found two things that can't exist in the same universe. The 12 jurors should have been able to figure out on their own they can't exist in the same universe, but apparently they didn't. So the jury, retrial, that's exactly what we can't do. We can't do that. That's exactly the problem. That's what Georgia did do. They can't do that, right? The jury found not guilty. You can't have them have a retrial on it. They've been found not guilty. That should be final. That's the end of the game. You can't order a retrial. That doesn't work. That's double jeopardy by definition. Yeah. That would necessarily be double jeopardy. He's already been on trial for that. He's already been found not guilty for that. You can't do a retrial. You're putting him in jeopardy again. This is a one and done thing. Judgment in favor of the accused is the end of the game. You can't do a new trial. That's what Georgia tried. It doesn't make sense. Do inconsistent verdicts provide for an acquittal? They can provide for it, yes. They can provide for it. There's only one way to do this, is to notch it down. The only thing that Georgia could decide not to care, the U.S. Supreme Court has told them they cannot care. But if they do care, there's only one way they can resolve it, and that's to resolve it in favor of the defendant. There's no alternative, at least in my humble opinion.
Does not prohibit the judge from saying, no, you can't do that. Go back and deliberate some more. Is that a violation? Is that correct? That's not a violation of double jeopardy?
If, in your hypothetical, from those inconsistent verdicts, one cannot ascertain whether there has been an acquittal or a conviction, then we believe that is distinguishable. And going back to your earlier question, going back again to 1896 in Ball, this court did hold that
Charles in chat says, isn't the judge after a jury verdict have authority to overturn the jury verdict on the grounds defense did not prove their case? No evidence was prevented for the jury to make that decision. No, absolutely 100% not. The defense isn't required to prove anything. Ever. The burden of proof is on the prosecution. The defendant is presumed innocent until proven guilty beyond a reasonable doubt. The defense is under absolutely no legal obligation to present any case at all, and they can win. Because if the evidence doesn't support a verdict of guilty beyond a reasonable doubt, and remember, the jury is the finder of fact, then the prosecution loses. So can they overturn an acquittal because there wasn't enough evidence presented by the defense? Not a chance. The defendant doesn't have to do jack shit. They can sit there like a bump on a log and still win.
The return of the verdict terminated jeopardy, notwithstanding that the indictment was invalid ultimately. So I think that is close to on point.
So what principle distinguishes, one more question along these lines, what principle distinguishes the situation where there are inconsistent jury determinations on one count from the situation where
Ellen Parker gives 20 gift memberships. Thank you very much, Ellen, for your continuing support. You've been a great contributor to the channel as of late, and I always want to make sure to make a special acknowledgement because you've been so supportive to the channel. Your continuing support is really appreciated. Thank you.
Where there are logically irreconcilable jury determinations on two counts. I don't – maybe there's a principle that explains that. Other than a formal difference, I don't really – it doesn't jump out at me why that should be different.
The difference, Justice Alito, is that double jeopardy has always been analyzed on an offense-by-offense basis. So the question is, was there a verdict on the particular offense? And if what the jury returns does not –
By the way, just to show you I continue to try to work on the audio, it occurred to me that I can add some sort of perhaps sound absorbing mat to the desk. So I got something that hopefully will absorb sound and help deal with reflection from the desk. So hopefully, after Saturday, the audio will be even slightly better. We continue to work on it.
Show that there has been a verdict. You can't tell what the jury determined, then it's appropriate to ask them to deliberate further. What the court can't do in that circumstance is to look at the content of two verdicts and say, we're going to compare the jury's findings on this count with its findings on this separate offense, and based on an analysis of the contents.
Is there a logical principle, though, that explains that, other than you just said it's always been that way?
In terms of Justice Kavanaugh, in terms
offense by offense versus, as Justice Alito says, one count?
Yes. Historically, each offense was brought in a separate indictment. This court held, I believe in Dunn, that when you have a multi-count indictment, it's still an offense by offense. And the logical principle is it's a different crime. Each count is a different crime.
I thought the distinction was rather more simple than that. I had one of those cases on the 10th Circuit where the jury came back on one count and said guilty and not guilty.
Yes.
And the judge said, I don't know what to do.
Yes.
You've not returned a verdict of acquittal. You've also returned a verdict of guilty.
Yes.
Go back and figure this out, folks. And that seems to me a world away from a verdict on any count that says this individual is not guilty in the eyes of his peers.
Exactly, Justice Gorsuch. And the opinion you wrote in the Shipley case didn't reach the double jeopardy issue.
Oh, I took care not to come close to this case.
You did say it about 3 times.
About 4 times.
How can a defendant be both sane and insane
It cannot be.
But isn't the principle that we have juries that their decision-making is sort of inviolate? In other words, the jury can nullify on a particular decision. We don't go back and try to figure out the jury's thinking with respect to inconsistent verdicts across different counts.
Justice Jackson spinning truth.
They can do whatever they want. That has been sort of a time immemorial principle with respect to jury deliberations, right?
Yes, Justice Jackson, and that's exactly why we propose this test of looking at the contents. What the state can't do, and what it is seeking to do here, is to look at the contents of the jury's findings on two different crimes and say we're going to compare those after the fact and throw out the equivalent.
But how is it different from Justice Gorsuch's question to say the defendant's both guilty and not guilty, and then in the next case the jury says the defendant's both sane and not sane?
The difference is that those verdicts in the second example are on separate offenses. And so it's no different than one of the cases this Court has dealt with. The defendant is convicted of conspiracy to possess cocaine, but acquitted of possession of cocaine. That's impossible. No different from a repugnant verdict. That can't be right. But this Court has consistently held you can't look at it after the fact.
We allow, I guess the principle, we allow juries to compromise in ways that are maybe not completely logical, but when it gets down to one count, they can't do guilty and not guilty. That's not a
Well, they can't obviously return guilty and not guilty as to the exact same count. That wouldn't be, that's not even possible. Well, I suppose it is, because strictly speaking, they have both check boxes on the form. So, yeah, so if they check both boxes for guilty and not guilty as to the same count, you'd be like, can't help noticing you checked both. Not sure which one you want. You want to, maybe work on the form a little bit more, because in that case, you're literally not sure what the jury's verdict is, right? Because it's not the jury returned a verdict. It's like you can't. Yeah. So if it's the exact same count, asking the jury for clarification, and I absolutely believe 100% that has been a case before. I absolutely have no doubt in my mind that somewhere, sometime, a jury as to the exact same count said both guilty and not guilty. Because basically anything that can happen has happened at least once.
acceptable compromise, is that?
Well, exactly in the sense
That's
that they haven't rendered a verdict on the charge.
Yeah.
So here, for example, if the charge is malice murder, if they come back and say guilty and not guilty, you don't know what the jury did.
You seem to have accepted a premise. That I'm doubtful about, which is you can't be insane on one count and not insane on another. But malice murder has a different mens rea than assault, correct?
It does, yes.
And so you can be not guilty by reason of insanity with respect to a malice murder, because you have to be able to have mental capacity enough to form that intent. But that's different than the assault intent, correct? The assault intent only requires you to injure, and this man could have had that. He was delusional about the reasons he was causing pain, but he knew he was causing pain, correct?
That's an interesting idea. Okay. That's an interesting idea. I'm not sure if I actually agree with it or not. I'd have to think about it some more. But it's an interesting idea, right? Because different counts. Well, first of all, it's the same exact murder. So for two different murders that occurred at two different times, then at least hypothetically, you could have a change of mental state, which would be odd, but it's at least hypothetically possible, right? If you kill some guy one moment and 5 seconds later kill a different guy, although it's unlikely, it's at least hypothetically possible that your mental state changed in the 5 seconds. But here, that's not the situation we're dealing with. We're dealing with the same exact murder, the same exact time. There's only one thing that occurred. And basically what Georgia is asking is for different things than the alternative, which is not uncommon. We do it a lot, especially in murder cases. Do you find, First-degree murder, second-degree murder, third-degree murder. Do you find this? Do you find that? Do you find assault? Do you find blah, blah, blah? So it's not uncommon to ask the jury like 5 different ways if it's murder. All right. So she is presenting the idea that the different charges require different mental states. Okay. And therefore, you could be insane with respect to one of those states, but not the other, or insane in part. Like, I can't recognize this, but I can recognize that. That's a tough needle to thread, man. It's a tough needle to thread. And you would need, like, a lot of evidence at trial to be able to, like, split that distinction, man. I guess maybe it's possible, but oof. Yeah, no intent doesn't mean insanity. It doesn't, yeah, right. I didn't say it did. Lack of intent does not itself imply insanity. You're absolutely correct. Hopefully I didn't say otherwise. Hopefully I didn't say otherwise. Just because you don't have intent doesn't mean you're insane. I agree. But having found insanity, it's like, you know, can you split that difference? Yeah. You could be guilty of the assault and not guilty of the intent to murder. Sure. Of course. That would make sense, but the reason is the insanity. So that's the specific situation I'm dealing with. Right? Could you be a sane person that does this? Yeah. Can you be an insane person that does this? But I don't have to deal with that complexity. It's a very interesting needle to thread.
The elements of the charges are different. And under Georgia procedure, though, the state had to prove the elements of each of those crimes to
What I'm saying is they're not necessarily. You're buying the other side's argument. That
on these facts, we believe that there are, in fact, inconsistent, repugnant verdicts because insanity is an affirmative defense in Georgia. The defendant has to prove it by a preponderance of the evidence. And here there was one single episode. Now, in different facts, and in fact, the Georgia Supreme Court in McElrath talks about a different case in which you could be sane, a defendant could be sane and insane at different times. I believe that one was shooting one person and then going down the hall and shooting a different person. But here, because the issue is the affirmative defense, it's exactly the same as to the 3 charges. The point, again, though, is the jury can go back, can nullify, and we don't know why they did what they did. It could just as the uncertainty is the same. We don't know why they found him sane on one count and insane on the other, just like we don't know why the jury convicted on possession with intent to sell, but not on possession. And Justice Jackson, your point's exactly right. You can't go back and question that. Once the jury comes back and says not guilty, that's the end of it. And
but what are the limits on that? Because the states can set some procedural parameters, right? So what
Absolutely.
if there was a rule that said, listen, if this has gone on, deliberation's gone on for more than 2 days, automatically it's a mistrial.
Yeah.
And then at the very beginning, or let me make it hours so it works better, say 6 hours, it's automatically a mistrial. And then at 6 hours and 10 minutes, the jury returns a verdict of acquittal. Does that count as a mistrial where jeopardy doesn't?
Well, what the court has held, is that in the mistrial context, if there has to be manifest.
Well, no, I understand the rule about mistrial, but I guess what I'm saying is the judge just waits. But the rule says, at 6 hours, it's a line, it's a mistrial. But the jury does still come back and return a verdict of acquittal. It's just that it violates this procedural requirement. Which side of the line does that fall on? I mean, the jury's returned a verdict of acquittal, but state law says it just doesn't count if the jury is deliberated for more than 6 hours.
Well, one of the interests protected by the double jeopardy clause is the defendant's right to have a decision by the jury that's impaneled. And so I think the question would be, is a 6-hour period that automatically triggers a mistrial so unreasonable that in fact violates double jeopardy? I would think it would. It's a judgment call as to how long, but that would be the issue. Can a state deprive the defendant of his right, her right, to have a decision by the particular jury that was impaneled?
So what kinds of procedural requirements can a state impose?
They're very broad discretion, as I said, subject to due process and right to jury trial, et cetera. But evidentiary, we don't, if you look at the amicus brief here, we don't question evidentiary rules can be set. Does all of the jurors sign the form or just the foreperson? Do you poll the jury? Hours that are deliberated? All of those procedural points. And the test that we think captures it is looking at the contents. And that's the red line that the state crossed here, is that the Georgia Supreme Court acknowledged it had two verdicts in front of it. No question it had. Justice Pinson in his concurrence dubitante pointed out it's a fiction. It's a legal fiction here that we have two verdicts and we're going to look at the contents, compare them, and based on that comparison refuse to honor a jury verdict. We're not aware of any other state that allows that, and we think it's a clear-cut violation of double jeopardy.
Thank you, counsel. Justice Thomas? Justice Alito? Justice Gorsuch? Justice Jack? Okay. Thank you, counsel.
Thank you.
All right, this better be good. This better be really good.
General Petrani?
Mr. Chief Justice, and may it please the Court. Petitioner Damien McElrath assumes again and again that there was a verdict in this case. But that's simply not true according to state law as determined by Georgia's highest court. Under Georgia's narrow, sensible repugnancy rule, a jury cannot issue special affirmative findings that facially contradict each other. These incoherent, contradictory statements do not constitute a verdict in the first place. They don't resolve the factual inquiry. In practice, this rule means a jury cannot declare a man both sane and insane at the exact same time with respect to the exact same act, as the jury purported to do here. That's why the Georgia Supreme Court held there was no verdict, no acquittal, and no convictions. McElrath does not challenge that underlying Georgia Supreme Court decision, which, of course, benefited him. And he doesn't explain why we should ignore it now, why we should assume that there was a verdict, even though state law tells us there wasn't. To the contrary, you have to look to the underlying state law to identify whether there is some final verdict or judicial order that could even potentially terminate jeopardy in the first place. And here, because there's no verdict, there's no termination of jeopardy, and the double jeopardy clause doesn't apply. Now, other states can have different rules about verdicts, but I think that Georgia's repugnancy rule, if anything, is the most sensible way of responding to a very rare set of circumstances. It's a generally pro-defendant rule that ensures the parties obtain an actual determination of the critical facts.
How is it pro-defendant to retry him on something of which he was acquitted? Okay.
And the critical fact of McElrath's sanity was not determined here. Therefore, he can be retried. I welcome the Court's questions.
If you only had one charge here, malice murder, would there have been a verdict?
Well, I suppose it depends on what the jury comes back with.
Well, but just
yes.
Everything is the same except it's only one charge.
Yeah, in that case, you would have a verdict.
So if this constitutes a verdict, if there were only one, why does it not constitute a verdict when there are two?
Because Georgia does not ascribe to the legal fiction that the jury is finding different facts when they're looking at the exact same.
No, that's not what it's. So you have a verdict. You say that if it's only malice murder that we're concerned about, that you would have a verdict here.
If that was all that was in the case, if that was the only thing going on, yeah, I don't see.
And just everything in the case is exactly the same except there's only one charge.
Yeah.
Would this constitute a verdict?
Yeah, I think under Georgia law as it exists today, that would be a verdict, yes.
So the problem is that up to that point, until you void the verdict, you have what constitutes a verdict. It's not procedurally defective. There's not a jurisdictional problem. You have a verdict that is subsequently voided because it's inconsistent with a separate charge. And I don't know how you get around the notion, and that requires you, by the way, to look at the substance of the verdict. And I don't know how you get around the notion that before you can do that, there actually is a verdict.
Well, no, Your Honor.
Yeah, I'm not sure that really works because, as we've sort of discussed many times and at some length, when we're looking at cases, we look at it count by count because that's how we roll, right? We have to look at each individual situation as it applies to them, and we have to look to the facts as it applies to each count. And so the jury returning the guilty or not guilty with respect to the count is a decision on that count, right? That's the verdict as to that count. All right. Now you suddenly are bringing other counts into the equation and saying we have an inconsistency between counts. But to say that you don't have the verdict as to each count, the only way to have an inconsistency is to have the judgment as to the count. You can't have an inconsistency unless you first have the judgments of the respective counts and you're like, whoa, that doesn't make sense. But George is like, well, because it doesn't make sense, therefore we never had a decision in the first place. You know, because the jury found guilty as to count 1 and not guilty as to count 2, that means they didn't find those things. So Georgia wants to have mutually inconsistent ideas. They found it, therefore they didn't. But you see, Georgia can't resolve it that way because the double jeopardy clause, right? Georgia is correct that these can't both exist in the same universe at the same time. Georgia can resolve that one of two ways. Georgia can either say, we're going to disregard the fact that they can't both exist because, well, once again, you know, each count is separate unto itself, and the jury apparently found that, so, you know, we'll ignore the inconsistency and move on with our lives. So they could do that. Or they could say, okay, we're not going to tolerate the mutual inconsistency because that doesn't make sense to our logic brains. But there's only one way to resolve the tension. Because double jeopardy, the only way to resolve the tension is by saying as a matter of law that guilty verdict must be not guilty. The only way to resolve it, because of the double jeopardy, is to resolve it in the jury's favor, or the defendant's favor, rather. It's the only way it makes sense. It doesn't matter if it doesn't logically make sense. I just told you the law. As a matter of federal law, the Supreme Court doesn't care. The U.S. Supreme Court has said that they're okay with the mutually inconsistent verdicts. So they're willing to live with it. They're willing to live with the tension. So the federal law allows for this. So you can resolve it that way. That's legal. But you can't, having decided that you care about the tension, resolve it this way. The way that Georgia resolved it doesn't work.
To be clear, here in this case there was never a verdict because, again, the jury issued something simultaneously. It said at the same time, speaking out of both sides of its mouth, he's both sane and insane at the same time. And these were special findings. As we explain in our brief, there's a big distinction between a jury coming back with a general verdict of not guilty, which, a jury has the authority to do that for any reason or no reason at all.
How do you define general verdict? Guilty, not guilty of both counts?
Well, a general verdict of not guilty just says not guilty and you're done, basically, and it doesn't go into any special findings as to what
the only special finding here had to do with whether it was excusable because of mental illness or because of insanity, correct?
Yeah, the special findings.
It's not a special finding with respect to the one charge that changes any of the facts of the acquittal.
Well, no, Your Honor, the special finding is that he was insane. If he had not been insane, he would have been guilty.
But that wasn't the question that was posed to the jury standing alone. I mean, I understand your argument if you're saying the jury was asked, is this person insane?
I like that, Emily. I like that very much. I like that. That's a good comment. I feel like this man is gaslighting the country. There was a verdict, but there isn't a verdict. I like that very much. That's a good comment. Plus 1 point for you. Plus 1 uncivilian point for you. That was a good comment.
Answer was simply yes in one situation or with respect to one count and no with respect to the other. but the jury was asked about the elements of a particular crime and whether he was guilty or not guilty. So their verdict was not guilty by reason of insanity with respect to one of them, and guilty, right?
Well, yes, Your Honor,
with respect to the other.
Not guilty by reason of insanity by definition means that you did commit the crime, and the only reason that we have said you're not guilty is because you are, in fact, insane.
I understand, but what do we do with the not guilty part of it? I mean, the jury was not asked on his special verdict form just the pure question of insanity in the way you sort of set it up at the beginning.
Well, actually, as a practical matter, Your Honor.
Oh, so you've been talking all this time about these special verdicts. This entire argument from you up to this moment was predicated on the basis that the jury wasn't asked just guilty or not guilty. They were asked an additional question, like, do you find this additional fact? Right? That would be what a special verdict is, by the way, right? Where you don't just ask them the ultimate question, you ask them the components of the question, right? So this entire argument up till now has been premised on, in both counts, we asked for the special verdict because we asked for the sub question. Now Justice Jackson says, wait a second, you didn't do that. And he's like, oh, well, it's a practical matter we did. Get absolutely wrecked. Get completely all the way wrecked. Well, it's implied.
I think that they were. I mean, this, even setting aside the more mundane aspects of this case where the entire trial was about sanity, they were given a special verdict form that has 4 options. The judge did, in fact, instruct them that they could say not guilty. They always had that authority. So it's not like Georgia is somehow trying to force the jury into, giving up its general power to just say not guilty for any reason. And part of the reason that we think this case is different from, the seemingly facially inconsistent verdict cases is precisely because in this case the jury didn't do that. It actually made special determinations.
Counsel,
special.
Just looking through the briefs, I didn't see another state that has a scheme like Georgia's that allows an acquittal to be rendered invalid based on its repugnancy with other guilty verdicts. Is that correct?
As far as I'm aware, there's no state that has addressed this particular issue, Your Honor. I mean,
yeah, perhaps completely unsurprisingly, given the double jeopardy law which exists and has been fairly well defined in law for some time. Yeah, I mean, double jeopardy goes well far back in law, So, yeah, unsurprisingly, no state has ever done this ever because it's incredibly illegal and unconstitutional, and obviously so. What is up with the Georgia Supreme Court? How do you get those bad judges to make this decision, which is so obviously batshit insane that no other state has even thought of this idea? Georgia in trying to invent new law, but there is that pesky Fifth Amendment. So not so much, Georgia.
These are rare circumstances. It's not ordinary for a jury to issue special findings on a particular issue going both ways. But yes, you are correct. As far as I know, there's no other state that has addressed this issue at all.
Now, shouldn't that tell us something? That 230 years in this
Preach it, baby.
History, we have respected acquittals without looking into their substance and without looking into how they fit with other counts, and said a jury is a check on judges. It's a check on prosecutors. It's a check on overreach. It's part of our democratic system. And we do not ever talk about whether they make sense to us. They may be products of compromise. They may be inconsistent with verdicts on other counts. We don't question them. And this is the first time this issue has arisen here. Shouldn't that tell us something?
I don't think so, Your Honor. As we point out,
unsurprisingly, as a Gorsuch fan, I just want to say hallelujah. Pretty much all that, exactly that, for 230 years. and actually well beyond that, because of course double jeopardy isn't a concept we invented. So yes, we have never ever ever looked into the question of does it make sense to us, especially when it comes to acquittals. Maybe on guilty we'll look into that, because maybe the jury can't, no reasonable jury, right? This is the idea. A judge can issue a judgment notwithstanding the verdict, JNOV. It's like the jury says guilty, how about not guilty? Or the Court of Appeals says, hey, no reasonable jury could possibly find this. This doesn't make any coherent sense. We allow for that, but we don't allow the other way, because double jeopardy. Acquittal, a judgment of not guilty is final, absolute, inviolable. We don't care. We don't care if there was literally all the evidence in the world. We don't care if the guys are charged of murder and, there were 100 witnesses and, 50 of them were nuns. And also there were 30 different video cameras filming the murder from every possible way. And also there was a note from the guy who said, ha ha ha, I'm planning to commit the murders. And then a different note smeared in the victim's blood that says, boy, oh boy, those murders were really, really fun. And then also confessed to the police, I did the murders. I totally did it. It was absolutely me. I had a great time committing the murders. If, when he goes to trial, he says, how about not guilty? And the jury's presented with all this, incredibly damning evidence, and they say not guilty. That's the end of the game. That's the end of the game.
Briefs, the fact that Georgia has a different rule from other states, and again, I would hasten to add, it's not clear that the rule's different so much as other states just haven't addressed this issue. In a lot of states, you might not have the same sort of defenses or states of mind that would so easily come into conflict, although, again, here, I think this is a rare circumstance. But to get to your point, absolutely, a jury's general verdict of acquittal is one of the most sacrosanct things in American constitutional law, and we're not trying to undermine that at all. But I do think it's important to point out that that's simply not what happened here. They had the option to do that, and instead they gave completely contradictory answers about a single factual question.
And that raises the question about Missouri's brief, for example. And their concern seems to be within a single count, that some states do that. And the case I had, where you just couldn't tell what the jury's verdict was on a count and send the jury back to figure it out. None of that's at stake here, right?
Well, I think the principle of the matter arguably extends there. I mean,
You'd have to extend it, but it isn't at issue.
Well, I think the logic is the same. The only difference between
No, the logic isn't the same. I mean, I'm sorry, I just have to reject that. Assume I disagree with that.
Okay.
Because the logic for 230 years is a verdict on a count is sacrosanct. Okay? Here we're dealing with not two counts, we're dealing with one count, and we cannot tell what the jury did. The judge doesn't know what to do. He doesn't have his instructions from the jury.
Well, Your Honor, I want to be clear about the 230 years. Every time the Court has talked about this and every time the Court has made rulings about this, it's always talking about a general verdict of acquittal. It's not talking about a circumstance where you have special findings that did not have the same sort of status, the same sort of...
Why does that make a difference? An acquittal is an acquittal is an acquittal.
Preach it. Preach it. Preach it from the heavens. Preach it hard. An acquittal is an acquittal is an acquittal. It's absolute. There are not many absolutes in law, my friend. There are not many absolutes. The lawyers almost always have to say it depends. Finding absolutes in law is hard. This is one of them. This is absolute. There is no exceptions. It also, incidentally, doesn't matter if the jury was bribed with respect to the acquittal. Well, it might, but we'll push past that. Yeah, acquittal's about as absolute as it gets. Yeah.
Oh, I think it makes
since time immemorial. Now you're telling us an acquittal isn't an acquittal if it's a special verdict form?
No, what I'm saying is it's not an acquittal if the jury did not in fact resolve the factual question that supposedly underlies that acquittal. And in this particular case, we know because they said two contradictory things that they didn't in fact resolve that.
We also know that the jury was polled.
Point.
They stood by this verdict. We know that there were no objections contemporaneously by Georgia prosecutors. And I think we also know that the Attorney General, at least below, said that acquittal is an acquittal.
Well, no. What the brief below said, and it was a tangential footnote that really wasn't getting into the issue, is that where there's an acquittal, double jeopardy applies. And we're not contesting that at all. Much like McElrath here today and throughout his briefing.
I thought the Attorney General said that retrying petitioner on the murder count would, of course, violate double jeopardy.
On the basis that there was an acquittal. But that brief didn't really get into that issue, and the primary brief in the case, the DA brief, did reject that particular position. But I'd also say, going back to, well, did Georgia, have a problem with it at the time? Well, no, because Georgia wanted everything to stay the way it was, of course. From Georgia's perspective, from the prosecution's perspective, it got what it wanted, right? There was, in fact, to the extent that you accept these as verdicts, to the extent you don't accept Georgia's repugnancy rule, McElrath would be in prison for life. So the only one who had an incentive to challenge this was McElrath, and he did.
Well, yes. Again, at the risk of being a broken record, Georgia could choose to ignore the inconsistency. Because as we talked about before, right, each count is unto itself. And the Supreme Court, as previously said, we don't know why they ruled not guilty in an inconsistent way. Maybe they decided to give a break. Maybe it was a product of compromise. Maybe, they were just, whatever. But we don't look into the reasons for not guilty. Right? So we just ask, so we can ignore the inconsistency. Georgia could choose to do it that way. So Georgia could choose to honor the jury's verdicts as they stand and say, okay, we don't care about the inconsistency. How about life? That seems to be a valid option. But what Georgia can't do is say we do care about the inconsistency. Therefore, how about a new trial as to the count where you were acquitted? That is not one of the valid options.
And his theory was,
it's not unusual for a defendant to challenge the guilty verdicts.
Oh, absolutely.
That's what appeals all are about. Are you saying, maybe you could get rid of the repugnancy rule, allowing him to say that the guilty verdicts are repugnant given the acquittal, but I don't see how it works the other way around.
Preach it, Justice Gorsuch, preach it. Yeah, you could get rid of the repugnancy rule. You could allow the tension to sit. That is a valid option. You could have honored the acquittal and the guilty verdicts at the same time and said, okay, well, you were convicted of that count, so how about life? But you can't go the other way. You can't go the other way. You can go the one way, say, okay, the guilty verdicts are repugnant given the acquittal, but you can't say the acquittal verdicts are repugnant given the guilty verdict. This is a one-way road, my friend. This is a one-way road.
Well, the point is that his theory was a Georgia rule that, as the Georgia Supreme Court, the highest arbiter of Georgia law, says there's no verdict at all. That's the theory behind this rule. And if there is a verdict, the rule doesn't really make sense anymore.
Before our inconsistency cases, there might have been a lawyer standing where you were saying our state has decided that when a jury comes back with two inconsistent verdicts, we're going to say that there's no verdict at all. Because after all, how can there be a verdict if there's inconsistency? And you're saying that and we rejected that out of hand and in numerous cases. So you're saying that there's a difference between that and this repugnancy situation. I guess I just don't understand what it is.
Yeah, so we've already dealt with this in the inconsistent situation, and now you're saying there's a difference because it isn't that they're inconsistent. It's because they're repugnant. which to my legal ear, given what they've been saying, is the same thing. They tried to put a new and exciting label on it. New and improved. It's not inconsistent, it's repugnant. From Georgia, who previously gave you inconsistent, we release our new product, repugnant. Right? And no, we appreciate that you gave it a new name and everything, but no, it's still the same thing. We're not fooled by your rebranding effort.
So could you explain it to me a little bit more?
Yes, Your Honor. The first point that I would make is that all of those inconsistent verdicts cases assume that there are verdicts to begin with. And none of them was the court looking at, well, was there...
But again, a lawyer could have come up here and say, as a matter of state law, we're going to just say that there's not a verdict when the supposed verdict is inconsistent with another one.
No,
so, the state could have made the exact same argument. And surely we decided against that argument when we decided those cases.
Well, my point was simply that no one was making that argument. Powell itself and the paradigm.
If somebody had been making that argument, surely we would have rejected.
Yes, I think you would have, but I think the reason that you would have, and I think that this court has said this, said it in Smith, it's last year, it said it elsewhere, is that there's something special about a general verdict of not guilty. It said this in Powell. This is something that goes back hundreds of years, that a jury's authority to say not guilty, even if we believe that he is in fact guilty, is something that goes, prior to the founding and beyond.
I mean, it seems to me that it's the exact same thing, really. I mean, when a jury comes back with inconsistent verdicts, we don't really know what happened. I mean, one possibility of what happened is the jury made a humdinger of a mistake. And another possibility of what happened is that the jury made no mistake at all, but instead decided to compromise something out or decided to show leniency of a kind that is within the right of a jury to show. And so, too, here. The jury might have made a humdinger of a mistake in the way that you're suggesting, but in addition, the jury might have decided to compromise things out or to show leniency. And in that sense, we would be intruding into the jury's deliberations as much in your case as in the inconsistency cases.
Preach it. Preach it. Yeah, preach it. We don't do this. We don't do this. Yeah, maybe they made a mistake. Maybe they compromised. Maybe they nullified. Maybe whatever. We literally don't care. That's been the law forever. That has been the law literally forever. Hey, did the jury make a mistake? Did they make a compromise? Did they nullify? Were they trying to be lenient? We literally never ask those questions when it's not guilty. Ever. Period. Never, ever, ever. Acquittal is final. What part of acquittal is final are you not understanding, Georgia? What part of once the jury says not guilty, that's the end of the game with respect to that count? Which part of this is confusing you, Georgia? Jeez.
If we adopted your rule.
No, and the reason I don't think that that's true, Justice Kagan, is when a jury issues a general verdict of not guilty, you don't know what the jury did, and you can't look into why. Here, you still aren't going to look into why, but they told you what they did. They said, we found him both sane and insane. And so it's just a very different thing. We're not hunting for some sort of internal thoughts of the jury or something like that. We have in front of us two different things that the jury said about the same question.
We found him both sane on one count and insane on another count, one of which led to a guilty verdict and the other of which led to an acquittal, because, let's imagine, we wanted to compromise. It's the exact same thing that you're asking us to look into, which we have always said we will not look into.
Well, I disagree, Justice Kagan, because I think in the case of a general verdict of not guilty, as this Court has said many times over the years, and again, even pre-founding, there's something special about that authority. As this Court has said, for instance, in Gowden, a case that we cite, Courts, by the time of the founding, couldn't force juries to issue special findings precisely because there was something special about this general verdict of not guilty. It allowed the jury the space to say, you are not guilty, and we're not going to tell you why. But in this circumstance, although the jury had the authority to do that, was instructed on doing that, they didn't do that. Instead, they came out and said, we think he's sane and insane at the same time. So I do think that that's a fundamentally different issue from the jury. And I think when a court looks at
no. I literally, I understand you, Georgia. I understand. I'll even assume, despite your earlier language, apparently this didn't happen. But let's just pretend it did. I still don't care. Let's pretend that they were asked with respect to each count separately. Hey, is this guy sane or is he insane? And they literally checked both boxes, where the boxes inconsistently between the counts. For one count, they said sane. For the other count, they said insane. It's like, oh, that doesn't make sense. So it's like, you're not asking us to pierce the jury and ask them what they thought because they told us what they thought. Yeah, I still don't care. I still don't care. Because, well, maybe the jury made a mistake. But, so what? Yeah, the jury found mutually inconsistent things. Once again, at the risk of repeating myself ad nauseum, this isn't a civil case, right? This isn't a civil case. This is a criminal case. There's a double jeopardy clause, right? No one shall be twice put in jeopardy of life or limb for the same offense. I believe is the language or close to it, the Constitution. And the jury, although apparently being completely moronic, checked the not guilty box and told you how they're moronic in their special filings. I still don't care. I don't care. The jury made a mistake. And you can ask them, hey, is this really your verdict? Did you really say that? Right? And then they can say, yes, we did. And, well, okay, we're done. So yeah, the jury, okay, moving on.
That and says, well, actually, you've decided the same issue in two different ways. I think it is a bit legally fictitious to say, well, they were really deciding two different factual issues. I mean, I know it's at least a little bit legally fictitious because this court, applies collateral estoppel rules to jury findings on a particular count. So we all acknowledge that there really is one fact that's being decided here, which is his insanity at the time of the crime. And the
collateral estoppel, by the way, would apply to a different count at a different time. Right? That's where collateral estoppel would apply. And by the way, also only with respect to the benefit to the defendant. Right? So if at some point they charge a guy and some point later charge the guy, which typically most states don't allow unless special circumstances, then the finding in one case will bind you in another case. Incidentally, that's also a civil law rule. By the way, collateral estoppel, the competent court having found something in a relevant case, you're obviously entitled to appeal. But once that's done, that's a finding of a competent court. And another court is going to say, hey, you can't re-argue the same thing. The court already ruled against you on that issue. Competent court already found against you. You're not allowed to re-argue it. Collateral estoppel. But I don't think that works against the defendant in a criminal case. I mean, it would work against the state in the criminal case. Okay. And even if somehow it did apply to the defendant in a subsequent case, which doesn't sound right, but let's press on. That's not this situation. This is the same case. So what is true in collateral estoppel land is not really the issue right now.
The jury said yes and no. And just to give one example of why I think McElrath's argument here is a little bit formalistic, suppose the jury form were slightly different. And suppose it had an option for guilt and then it had a different option for insanity. And they said guilty on all counts on insanity, or on the guilt question, but then on insanity they said yes and no.
Okay. In that hypothetical situation where they're asked the insanity question separately and check both yes and no, at that point the judge doesn't know their instructions. That would be the same thing as them checking guilty and not guilty on the same count, right? They can't check both boxes. If they're asked guilty or not, and then asked insanity or not, and they check both boxes, the judge literally doesn't know what to do. It's like, you check, I don't know what you believe. So at that point, that would be fine. We've discussed that before. Justice Gorsuch, sitting on the Court of Appeals, had exactly that situation with the guilty and not guilty, and apparently ruled in the Court of Appeals when he sat there. It's like, well, in that situation, the judge doesn't know what to do because they check both boxes. It can't be both on the same count. But so in that situation, could you ask the jury for clarification? Sure, because you don't know what to do. So the situation is inopposite, as we say in law.
I mean, that's the same circumstance that we're in here. It's not fundamentally different. It's a jury not actually deciding whether or not they have come to a conclusion.
General, are you saying that you can never have plainly inconsistent general verdicts? Are you just saying, I mean, because it
yes,
kind of
as a factual,
like
yes, as a factual matter, yes, I actually think that's true, because you could never know. The jury might have just said, yeah, you're guilty as sin. All the facts are there, but we don't care. We're going to say not guilty anyway. So you can never know that what they did was factually inconsistent. They might have just said, yeah, you did it all, but we're going to let you off on this particular count. So I think it's just a matter of logic. You can never know that two general verdicts are absolutely inconsistent with one another. That's why in our brief we referred to it as kind of seemingly inconsistent. But because the jury could be deciding this on a totally non-factual basis, you can't know that they're actually inconsistent.
But wasn't Justice Gorsuch's point that even if we know that they are inconsistent, so what? I mean, the point is that we've said a jury can issue inconsistent verdicts. So your argument seems to be, well, there's the distinction that Justice Kagan was asking you about is that in one situation we don't know it's inconsistent, in another situation, this situation, we do know. Okay. I mean, fine. So it's inconsistent. Why does that mean that the court gets to say you aren't able to do that, jury? You can retry this person, or you have to set it up so he can be retried, because that's not a valid thing for the jury to do.
Justice Jackson, again, making some good points. Yeah, the Supreme Court has previously said, as a matter of federal law, we're cool with the inconsistency. We'll let it ride. So, the jury is allowed to be inconsistent. Again, Georgia can take the view that we don't like the inconsistencies, but the way that they chose to resolve it is not one of the options on the table. So, yeah.
Well, 2 points, Your Honor. The first is it's not, I'm not speaking from nothing when I say that the inconsistent verdicts cases are different because we don't know what the jury has done. This is what the court has said. We don't know what the jury has done. But the second reason is, I think the reason that the jury can issue a verdict of not guilty, a general verdict of not guilty, and the state can't say, oh, that's not really a verdict because it may or may not be inconsistent with this other one, is because of the right to a jury trial and the fact that, as this court has explained on numerous occasions, a jury always has that authority. A state can't say you don't have the authority to issue this general verdict of not guilty. And we cite several things in our brief. I don't think McElrath
I guess my question is why is it, and I think your argument is turning on this, that a state can tell the jury they have to be factually consistent? So even if I accept your distinction that you are drawing with Justice Kagan, and that, in this particular world we have evidence that there's a factual inconsistency with respect to the way they rendered their verdicts, why is it okay for the state to say you can't do that?
Again, 2 points, Your Honor. The first is, I think, that as a matter of sensibility, the jury is supposed to find facts. If they don't find the facts, if they instead tell you two opposite things, it makes a lot of sense to say the jury has not, in fact, found this fact. But the second one I would say is it's McElrath's burden to identify why a state can't do this. It is the strong presumption that a state does have authority over its own criminal laws and procedures. And unless there's something in the, kind of fundamental right to a jury trial or something like this.
Isn't it the Constitution? I mean, I thought.
Yeah, that's the problem. Yeah, Justice Jackson pointing out the obvious. Well, it's not, there's a strong presumption that states are allowed to have control of their own process. I mean, where does it say we can't? Right here. this part right here. Double jeopardy clause. Have you heard of it? Have you heard of it? Oh my God.
I guess my question is, isn't this a matter of federal law as to whether or not what is happening here is an acquittal or not an acquittal for the purpose of the double jeopardy clause?
So what a state order or finding or something like that, the effect that it has for the purposes of double jeopardy is ultimately a federal question. But what the state order is and whether it exists in the first place, that's not necessarily a federal question. And I would point the Court to Smith versus Massachusetts and Sadazan versus Pennsylvania. In Smith versus Massachusetts, the Court did hold that this mid-trial judicial acquittal triggered the double jeopardy clause, but it said if Massachusetts had a rule that this wasn't a final order, that it could be revisited, that they could come back to it later, well, then it wouldn't trigger double jeopardy.
Well, so then, what if the state had a rule that the foreman has to sign the verdict in blue ink, all right, and he signed it in black ink, and the judge, it's supposed to be blue ink, go back. He goes back, and then one of the jurors changes their mind. Is that rule of state law sufficient to constitute a determination of when jeopardy was terminated?
Yeah, I think if the state has a
You
rule,
think it is?
Yeah, I think if the state has a procedural rule that has to be complied with, and by the time that it was complied with, the jury is not unanimous, I think the general presumption would be yes, it's fine. If there's something
you wouldn't
about
think that that's a frivolous rule that shouldn't impede the federal law determination?
So, well, this is what I was going to say, Your Honor. As this Court has said many times in many contexts, whether it be property or last year in the Elections Clause, at some point, if a state rule is so outside the bounds of kind of normal, reasonable legislation or adjudication, then you might say, well, you're just evading, some federal right here. So in the property context, you can't just redefine a taking a tax or something like that.
They've done that before. They've tried to do that before.
The state is allowed to do this unless there's some way in which it's evading federal constitutional guarantees.
Well, and I guess the argument would be, even in the context of your understanding, that it's the only state that has done this in 230 years, and maybe that's outside the or normal understanding.
Yeah, so that is, at the very least, that's the right kind of argument that
Charles says, why can a jury verdict be overturned by a judge in a civil case but not criminal? Well, in a criminal case, it can be overturned in favor of the defendant, but it can't be overturned the other way around because double jeopardy issues, right? The jury is the finder of fact. That's why, right? The jury is the finder of fact, and they're not guilty. It's like, yeah, it's just the end of the game. It's the rule. It's just the rule. So yeah, you can't have summary judgment against the defendant in a criminal case. You can't be like, oh, you're just guilty because it's so obvious. We just have a jury system, and all the facts in the world don't get you past the not guilty. So you can't do it because there's a constitutional right to a trial by jury. That's why. There's a constitutional right to a trial by jury. And so the jury says not guilty, and you're presumed innocent as a matter of law. So you're presumed innocent, and the jury, which you're entitled to, says not guilty, which, so that's pretty much why. That would be why,
McElrath should be making here, but the reason I reject that is because, first of all, I don't accept the notion that no other state has ever had a rule anything like this. It's true that no other state appears to have actually come across facts exactly like this, but we point to examples in our brief, and the Missouri amicus brief has others of kind of similar situations where they do, in fact, have rules that appear at least similar or analogous to our rule here. And we also point to cases like in the Morgan article from before the founding, where cases, especially where special verdicts seems to be inconsistent with even general verdicts of
You hang a lot on the special findings being different from a general verdict, but couldn't the inconsistent or repugnant special findings be the product of compromise or leniency?
Well, I think that this goes back to my answer to Justice Kagan earlier, which is we don't look behind what the jury did to sort of understand their motivation. So they issued special verdicts that are completely incomprehensible when put together.
Couldn't they be the product, I guess go back to my question, couldn't they be the product of compromise or leniency?
Yeah, they could have, I mean, what the jury did, I have no idea. I wasn't in the room, and that's kind of the point.
But it could be compromise.
It's at least theoretically possible that the jury wanted to do something like be lenient or something like this. But the reason that a general verdict is so different.
Or compromise, right?
Yeah, although I don't take the court's mention of compromise in the inconsistent verdicts cases to be sort of blessing that as something that's like good for a jury to be doing necessarily. It's just you can't tell. They could have done any number of things.
Well, the founders certainly thought it was important.
Breach.
Go back to the trial of John Zanger. He was guilty as heck. And yet the jury acquitted him. And that was considered one of the great moments in American history leading up to the adoption of the Seventh Amendment. And so I guess Justice Kavanaugh and I think Justice Kagan have put their finger on it. The minute you admit that it could be a product of leniency or compromise, we're done, aren't we?
Well,
because then we have to respect that verdict, regardless of whether we think it's rational or what we would do. It's supposed to be a check on us judges and you prosecutors.
Your Honor, prior to the founding, there was a period of time.
I'm beginning to speculate that Justice Gorsuch is not going to vote in Georgia's favor. Just some small context clues that I'm potentially picking up on. Seems like Justice Gorsuch is probably voting no on this one. Yeah.
Courts would try to sort of corral juries by forcing them to issue special verdicts. And what came out of this was that the way we are going to make sure your right to a jury trial.
Dominic says, could this be 9-0? I fully expect this to be 9-0, and I hope that they beat Georgia to death on the page. Because Georgia did it bad. I hope they beat them to death in legal language and show them how they are complete incompetent idiots. And call Georgia out. This really calls for a, are you serious? Were you actually serious when you presented this stupid issue to us? This is so incredibly dumb. You know this. How can you not know this? You're an idiot. So I hope they beat them to death on the page. That's my wish.
Is always a check on the executive, the legislative, whoever else, is by making sure you can always get a general verdict of not guilty.
Right.
So that's how I would.
I guess if you'd answer the question, though, the moment you admit that that verdict could be a product of compromise or leniency, why isn't that the end of the game?
Because I don't think that the jury necessarily, I don't think the right to a jury trial includes the right for the jury to try to issue completely incomprehensible special findings to sort of game out what they're doing. So in this case, for instance.
Or is it really you're saying that the jury doesn't have a right to do leniency and compromise?
No, Your Honor. They obviously do, and they could have in this case with a general verdict of not guilty. But to be clear, when they issued this purported verdict, assume you accept it, it has consequences for McElrath. So the idea that the jury can, consign him to a mental health hospital until he is, determined not to be dangerous anymore as sort of some version of leniency, I think is getting way outside of the ordinary general verdict of not guilty is the jury's ultimate.
Well, that's one thing that, I'm interested in your view on. You seem to say this is different than inconsistent verdicts, which could be explained by juror compromise, leniency, whatever. I don't know why the same thing doesn't apply to repugnant verdicts. I don't know that the jury necessarily would be as sophisticated as the counsel today in explaining what's a repugnant verdict versus what's an inconsistent verdict. And after back and forth, it might be compromise. Okay, we're going to say he's sane for this and guilty. He's not guilty by reason of sanity. This group is fine with one, that group is fine with another. I don't know that they thrashed through the law about whether they would have to be reconciled or not.
Yeah, Your Honor, I think that the reason a general verdict of not guilty is different is because of leniency. I don't think that a state is powerless to basically say, no, you're not allowed to compromise by coming to completely incomprehensible conclusions.
Dominic on Twitch says they can't post clips. Yeah, sorry about that on Twitch. I'm new to Twitch, so I don't really know Twitch. So I don't know how clips work and enabling clips. So if one of you guys can tell me in chat how to do that, I'll go into Twitch and fix it in the background while we're talking. So yeah, I don't know how to Twitch. Someone teach me.
I do think a state is prohibited from keeping a jury from issuing a general verdict of not guilty because of the jury's historic function as a check on the executive. And I think in this case, the jury had the authority to do that. It had the power to do that. It chose not to do that. Instead, it issued special findings that nobody knows necessarily the motivation, the internal motivation of the jury for that. But what we know is what they actually did.
You keep talking about general and special verdicts, and having tried so many cases, I think of special verdicts as verdicts where you ask each element of the offense separately. And then you come to the judge then decides whether that's a guilty or not guilty. A general verdict is, are you guilty or not guilty, but based on the elements, based on whatever special defense.
I think I have a solution.
And almost always you had, is he guilty by reason of insanity or not? That's what they did here, right? On the malice murder?
It was not guilty by reason of insanity. Yes.
Right. They didn't ask, did he have malice, the intent to kill? Did he kill this person? They just said, is he guilty by reason of insanity or guilty but with mental illness, correct? And they just checked off which of the elements.
Yeah, they had 4 options.
All right. So in Smith last year we said an acquittal takes place when there is a merits-related, quote, resolution, correct or not, of some or all of the factual elements of the crime charged. Here the jury was given malice murder. One of the factual elements is the mental state, guilty by reason of insanity or not. They said not. I don't know how this doesn't fit Smith's definition of what an acquittal is. You want to call it a general verdict, but Smith said all we're looking at is what the jury did. And the jury said not guilty by reason of insanity. You told Justice Thomas that if it just stood alone that way, jeopardy attached. I still don't understand how you unattach it simply because there's a second charge with a potential inconsistency that you now admit could have been by reason of jury compromise.
Briefly, counsel.
Yeah, Your Honor, I don't think states are prohibited from trying to avoid incomprehensible compromises. I think it's just leniency that they have to leave in there with general verdicts of not guilty. As far as whether this is a special verdict or not, the Georgia Supreme Court understood it that way. McElrath understood it that way. That was the basis of his argument all the way along, including in his plea and bar in this case. And so the big difference ultimately is that the jury always has the authority to just say not guilty. We don't want you to be guilty of this crime. I don't think there's any historical or other support for the idea that a jury must have the authority to issue incomprehensible special findings.
Thank you, counsel. Rebuttal, Mr. Simpson? Oh, I'm sorry. We've skipped the
Ready to jump in.
No, excuse me. Anything further? Just leave.
I do have some further. Sorry. If you do not prevail in this case, I have 2 questions. One is, can't Georgia going forward solve the problem that you've identified by simply saying that the guilty verdicts stand even if repugnant?
Yeah, so if we were to lose this case, I think not only could they, but that is the only logical thing for the Georgia Supreme Court to do, because the basis of this rule was there are no verdicts at all. Georgia accepts the basic idea that if these are seemingly inconsistent, we'll just accept them as they are. The basis for this rule was we don't think these are verdicts at all. If this court says, yeah, they are, then I think basically whether McElrath or the next person in his shoes is just going to be stuck with the life in prison conviction.
Is that still possible in this case?
Yes, I think so. I mean, obviously it's going to be up to the Georgia Supreme Court to figure out what to do going forward, but the initial decision was based on the idea that there was no verdict here. And so if this court were to vacate and remand and say, nope, there was a verdict here, then presumably the Georgia Supreme Court would at least take seriously the argument of, okay, well then we just reinstate the judgment because the United States Supreme Court just said there was a verdict.
Thank you.
Justice Jackson? Thank you, counsel. Mr. Simpson, rebuttal.
Mr. Chief Justice, may it please the Court. Justice Thomas, you're exactly right that under Georgia law, each of these counts, if it had been charged separately, at the verdict would be a final verdict under state law. It's only by comparing them that you get to repugnancy. It is true that Mr. McElrath appealed in this case. He had the right to do that under Georgia law. And going to Justice Kavanaugh's question, under Powell, states may, as the federal government does, when there are inconsistent acquittals and convictions, may allow the conviction to stand. They can't touch the appeal. It's may, not must. Many states throw out the conviction. It's a state choice at that level. And there was the Georgia Supreme Court in the Turner case in 2006, I believe, dealt with what it had said as repugnant verdicts, and it did exactly that. It let the acquittal stand, but it vacated throughout the conviction. We would hope that Georgia would continue to follow that rule. It'll be its decision, but there's nothing about a decision by this court that would require Georgia to change its rule. And in the context of Turner, it reached exactly the result of allowing the acquittal to stand and throwing out the conviction. In terms of repugnancy, I think the key point, as the questions indicated, there really isn't a principal difference. Here, Mr. McElrath was acquitted of the most serious charge, convicted of the lesser charge, could have been leniency, could have been compromise. We don't know why the court the jury reached that verdict. And then finally, the reference to issue preclusion, where there's a conviction and an acquittal, this court has held that issue preclusion is not mandatory. So again, Georgia may, but is not required to. Unless there are additional questions, I would yield the remainder of my time.
Thank you, counsel. The case is submitted.
All right, my friends, so that brings us to the end of that stream, and yeah, I fully expect Georgia to be shut down 9-0 on this one, because it's pretty freaking dumb. This doesn't make any sense at all. So yeah, his conviction for the other charge may very well wind up existing, possibly, and so he gets life in prison because he was convicted of that. And that's a way to resolve that, so no double jeopardy. So maybe he winds up in prison for the rest of his life anyway. But still, the thing was pretty stupid. So, yeah, that should be the end of that game. So it may be somewhat of a meaningless victory for him in his case, but, might help someone else in another case, of course. And, of course, whatever it does or does not help him, we need to get the law going. So all that stuff, I sent the rest of it. You sent me the opinion on double jeopardy? Oh, yeah. All right. So first of all, I'm still trying to figure out how to allow clips on Twitch, and I need to whitelist the URL for the clips, but I don't know how to whitelist the URL because I keep looking at people telling me how to do it, and they say open up moderation menu and then open up whitelist, but I'm in the moderation menu and I don't see whitelist, so I'm very, very confused. Twitch sometimes, well, it's not native to me because I haven't been using it that long. So how do I whitelist the URL so people can post clips in my chat? Anyone have any clues how I whitelist that but still block links in general? I can turn off the blocking of links completely. Mod menu under the content creator dashboard. Yeah, I'm in the content creator dashboard. I'm in Let's see, settings. I'm in under settings, moderation. And I don't see a thing for whitelist. And when I search for white, it doesn't pop up. Yeah, you got the appellate decision aligned Jan 6 lawsuit to go forward. I saw that. So I saw that on Discord. Later tonight, we're going to be doing the Jesse Smollett case. We might do the Trump thing another day. How do we whitelist these things? I hate trying to do technical things while I'm trying to talk to you. Block terms and phrases? No. Permitted terms and phrases? No. Automatic mod settings? No. Block hyperlinks is on, but I don't see any option. It's just a checkbox. There's no option to whitelist it. I don't know how to enable clips. Its own setting somewhere. I can't find it. I can't find the option to whitelist. Moderation, then open general settings. Moderation, general settings. There is no general settings under moderation. Is there a different way to find my moderation tools than under the thing? Damn it. I'm really sorry. I can't find where to put it. Handle it later? Fine, I'll handle it later. I'm sorry. I just was trying to fix the problem. Let's move on to something else. Let's move on to the Georgia decision and laugh at it. Okay. Give me a second to pull that up. Didn't one of you guys said you emailed me the Georgia decision? Where's the Georgia decision so I can review it? Is it on Discord? I don't see it. Where is it? Oh, here we go. In general, in Discord. Okay, fine. Cool. All right. So give me a second to put that up. And adjust the tabs and everything. So give me a second to adjust the thing. I'll show the screen and someone might be able to help. Fair. Okay. So do we want to tech this thing, or do we want to move on to the case? We should probably move on to the case. We spent enough time trying to dick around. I don't want to waste time dealing with moderation issues. It's not essential. It's nice to have. We'll fix it later. Okay, here's the underlying opinion from the Georgia Supreme Court against the guy who says, yes, we can totally do this. It's not a double jeopardy problem. Let's read the stupid from the Georgia Supreme Court. All right, this is the second appearance of Damien before the court. In 2017, a jury found him guilty, but mentally ill as to felony murder, but not guilty by reason of insanity as to malice murder, following a single contemporaneous encounter between him and his mother. The trial court did not recognize the verdicts as repugnant and accepted them. On appeal, we held the verdicts were repugnant and thus vacated the verdicts and remanded. On remand, he filed a plea in bar alleging retrial was precluded on double jeopardy grounds, which the trial court denied. In this appeal, he argues the court should have reversed rather than vacated his felony murder conviction in his previous appeal. He also challenges the trial court's ruling on a plea in bar, contending retrial on all counts is barred because the jury found him not guilty by reason of insanity. As we discussed below, both these arguments fail. Okay. He argues the court erred in his prior appeal where he determined the verdict should be vacated because they're repugnant. He argues that instead our court should have allowed the jury verdict of not guilty by reason of insanity to stand and should have reversed on the guilty by mentally ill on the felony murder. However, the issue's already been decided in the earlier appeal by this court where he determined the verdicts were repugnant because they could not logically or be legally held. This was because the not guilty by reason of insanity verdict on malice and guilty but mentally ill verdict on felony based on aggravated assault required affirmative findings of different mental states that could not exist at the same time. I still don't care. Put simply, we determined based on evidence presented it was not legally possible for him to simultaneously be both sane and insane during the single episode. Therefore, we determined that purported verdicts rendered by the jury were a nullity and should not have been accepted. Oh, Lord. Accordingly, we vacated on guilty but mentally ill and also the not guilty by reason of insanity and allowed for retrial. Our decision on the prior appeal is the law of the case. Well, that much is true. It's just really, really dumb law. Under the law of the case rule, anything by the Supreme Court or Court of Appeals in case shall be binding in all subsequent proceedings. That's correct. Yes, we don't, once the decision's made by the appropriate level of appeal, we don't relitigate it, right? So it's the whole idea of res judicata, right? It's res judicata within the same case, so we call it law of the case, but it's the same exact idea. It's well established the law of the case doctrine applies to a holding by appellate courts in criminal cases. Sure. Therefore, the questions of whether the conviction for felony murder should have been reversed rather than vacated has already been decided by this court. True, but you could, and that was binding on the trial court. Yeah, maybe that's true. Maybe the trial court was forced into the stupid, but probably you should recognize the stupid. Now would be a really good time to reconsider the stupid. Georgia Supreme Court, are you sure you don't want to reconsider the stupid? Based on the foregoing, it's clear this appeal is not a proper vehicle for challenging this court's earlier decision. Why not? Supreme Court could reverse itself. Why not? Under our court rules, they could have filed a motion for reconsideration. Accordingly, we do not reconsider here our earlier ruling. That sounds really dumb. They next argue that jury found him not guilty by reason of insanity on malice. He cannot be retried on any of the counts because the constitutional prohibition against double jeopardy and doctrine of collateral estoppel. Okay, yeah, the collateral estoppel applies to him. It's a strange way of going about collateral estoppel. But I guess it's an idea, right? Having decided, but we allow inconsistent verdicts. So yeah, collateral estoppel doesn't quite work here, but it's an interesting idea. The Fifth Amendment to the Constitution guarantees criminal defendants protections against double jeopardy. Likewise, the Georgia Constitution provides no person shall be in jeopardy of life or limb more than once for the same offense, except when a new trial has been granted after conviction or in the case of a mistrial. Neither of those things are true here. So not only are you violating your own Constitution, you're violating the Supreme Court, the federal Constitution as well. That's fun and exciting. The doctrine of double jeopardy encompasses both procedural and substantive aspects, the former barring multiple prosecutions for crime arising out of the same conduct, and later barring multiple punishments for the same crime. Preach. As the United States Supreme Court and this court have noted, a fundamental principle of procedural due process is a verdict of acquittal is an absolute bar. Yes. The bar against double jeopardy also encompasses the doctrine of collateral estoppel, which precludes relitigation of an ultimate finding of fact that was determined by a valid court. As the Supreme Court has explained, collateral estoppel is an awkward phrase, but stands for the important principle in our system. It simply means that when an issue of ultimate fact has once been decided by a valid and final judgment, that issue cannot be litigated again between the same parties. So maybe collateral estoppel here should apply too. So maybe how about not guilty across the board? Because also collateral estoppel. That would be super fun if the Supreme Court says that, because they obviously know if they simply say, hey, no on the double jeopardy without more, George is absolutely going to say, okay, well, we keep the verdict and they'll just have to decide this again another day. So it won't surprise me at all if the U.S. Supreme Court says, oh, yeah, by the way, collateral estoppel precludes you from hearing the guilty verdict as well, because you could have accepted the inconsistencies, but you didn't. And now you're trying to retry and the acquittal is final, right? So you could have accepted the inconsistency, but you didn't. You ordered a new trial, so now you're collaterally estopped from the earlier trial. So no new trial for you. That could definitely be a thing, yes. So maybe the Supreme Court will do that. I totally can see them doing that because they're so pissed. Because this is so incredibly stupid. I wouldn't bank on it, but I can see them doing it. Based on the principles, he argues the jury's verdict of not guilty by reason of insanity as to malice murder bars retrials to this charge as well as other charges. Under general principles of double jeopardy and viewed in isolation, the jury's purported verdict of not guilty by reason of insanity would appear to be an acquittal that precludes retrial, as not guilty verdicts are generally inviolate. So they think collateral estoppel would apply in this issue. So, yeah. Even if a verdict is based upon egregiously erroneous foundations, the finality is unassailable. This has been the law for a hot minute. The protection of the double jeopardy clause by its terms applies only if there's been an event such as acquittal which terminates jeopardy. Viewed in context alongside the verdict of guilty but mentally ill, however, the purported acquittal loses considerable steam. Because the verdicts were repugnant, both are rendered valueless. That is not at all how this works. The Supreme Court of the United States is going to beat you to death. Why are you such a bad court, Georgia Supreme Court? What is your problem? There's no way to decipher what factual findings or determination they represent, and the suspect or defendant cannot be said with any confidence to be found not guilty based on insanity. Any more can be said the jury made a finding of insanity and guilt with regard to the same conduct. Where a jury renders repugnant verdicts, both verdicts must be vacated and new trial ordered. Okay. Thus, the verdicts failed to result in an event that terminated jeopardy, akin to a situation in which a mistrial is declared after unable to reach a verdict. Accordingly, the general principles of double jeopardy do not bar this retrial. You are out of your goddamn mind. But that does not end our analysis. It really should, because you're incredibly wrong. The defendant further argues the doctrine of collateral estoppel, which is encompassed by the prohibition, would also bar retrial. As explained in Division 1 above, the verdicts returned by the verdicts were repugnant, and any judgment and sentence entered repugnant verdicts are void. No. In considering whether verdicts were repugnant and thus void, we've held no valid judgment be entered on a void verdict. Simply stated, the repugnant verdict of the sort rendered by the defendant in the first trial is no verdict at all. I think the U.S. Supreme Court is going to sharply disagree with you because it did not represent a resolution, correction or not, of some or all the factual elements of the offense charge, and collateral estoppel only applies when there's been a valid and final judgment. Pretty sure the judgment of acquittal is final and, absolute. Moreover, where it's true collateral estoppel may completely bar a subsequent prosecution, one of the facts necessarily determined in a formal proceeding is essentially an element of conviction sought. This case does not call for a straightforward application of the collateral estoppel rule. Doesn't it, though? Doesn't? If that's the rule, seems like collateral estoppel to me. You could have lived with the tension. But having decided not to live with the tension, collateral estoppel is looking more and more likely. They argue the issue of insanity at the time he stabbed his mother to death was an issue the jury actually and necessarily decided in his favor when found not guilty by reason of insanity. However, the jury spoke both through an acquittal by reason of insanity and conviction of guilt, but mentally ill, finding them both insane and sane at the same time. You could have lived with the tension. You didn't. The whole collateral estoppel analysis is premised on the proposition the jury acted rationally and lawfully. Not in this situation, no. No, that's not how that is premised. The jury is allowed to act irrationally and even unlawfully when it comes to finding acquittal. That's how serious we take this when it comes to this. The law is not ambiguous on this point. This has been decided many, many times in law. The law is not ambiguous. The jury has the power, if not the right, but the power to be batshit crazy, to completely defy the law, and the power, but not the right, to nullify. So if they do say not guilty for whatever reason, that's sort of the end of the game. So it's not premised on the jury acting rationally or lawfully, because not guilty is kind of final. The jury being out to lunch for the defendant is, just the end of the game. No reasonable jury could find for acquittal. Unfortunately, we can't draw that conclusion. Get absolutely wrecked. The no reasonable jury thing doesn't work when it comes to acquittal. No reasonable jury can find it, but they did, so end of analysis. When it comes to acquittal, the problem is the same jury reached inconsistent verdicts, ones that establish principle of collateral estoppel, which are predicated on the assumption the jury acted rationally, are no longer useful. Get wrecked. Because the not can be said with any confidence the jury made a finding of innocence based on sanity, which they clearly did, apparently. Anymore, it can be said they found admitting sanity and guilt. The doctrine of collateral estoppel doesn't bar retrial. Yeah, it kind of does, because you decide not to live with the tension, and voided the verdicts. So, yeah, I'm not sure at this point you can go back in time. I'm not sure the Supreme Court of the United States is going to give you the out. Because, yeah, you could have lived with it, but you didn't. You vacated the verdicts and voided them and tried to do a retrial again, which you can't do. So now you are collaterally estopped from the earlier trial. Exciting. Thank you, E. Caroline, for subscribing over on Twitch. We really do appreciate all the support, and we appreciate everyone who also watches on Twitch to help the watch time. And I will figure out, if it kills me, how to allow clips on Twitch. Because it can be said, finding accordingly near the doctrine and affirmed unanimously. Affirmed unanimously. Jesus Christ. What is going on with the Georgia Supreme Court? How did you all agree to this? How did you all agree to the stupid? It doesn't make sense. It's legally infirm. Please stop doing this. All right, Justice Pinson wants to write some comments. He concurs, but with reservations. He should have some very severe reservations indeed. It has long been settled under the Fifth Amendment that a verdict acquittal is final, ending jeopardy, and even where not followed by any judgment, is barred to subsequent prosecution. Correct. Correct. Even if the jury is batshit nuts. Not guilty is not guilty. Thank you, Guy Seppi, for the gift membership. We do appreciate every gift membership. Thank you. And the United States Supreme Court has explained that the finality of verdict acquittal holds, even though it was based on an egregiously erroneous foundation. Batshit crazy is fine by us when it comes to acquittal. The jury can be loco in the head. We still don't care. That's how seriously we take this. And even where a jury returns inconsistent verdicts, convicting on one and acquitting on another, where they turn on this very same issue of fact from some sort of decision there, explaining the circumstances barred from double jeopardy from challenging the acquittal. Breach. The court has nonetheless conclude here the state may seek to retrial an account for which the jury returned acquittal. I follow the logic as a matter of Georgia law. Do you? The acquittal was a repugnant verdict. A repugnant verdict is void, which means unlike a merely erroneous verdict, it's not a verdict at all. I'm not sure what the difference are. You keep using different words like they're different things. You can't just magically slap a different label on it and say, oh, okay, it's not erroneous, it's repugnant. It's not inconsistent, it's repugnant. You can't do this through word tricks. And so the jury never reached a verdict that ended in defendant's jeopardy. Further precedent supports the idea that a void acquittal is no bar to precedent, which apparently they cite the United States Supreme Court on this proposition, making the point with respect to an acquittal before a court having no jurisdiction. Yes, that was a recent decision by the U.S. Supreme Court. So in that particular issue, the court that decided the issue of acquittal didn't have jurisdiction. So therefore, it's a legally void verdict because the court wasn't a valid court to consider it. So, yeah, the jury wasn't a valid jury. So that was the problem. So the Supreme Court said, yes, if, this court couldn't decide the issue, then they can't decide the issue. So you weren't in jeopardy because the court was void ab initio. It was invalid from the very beginning. It was never allowed to do this in the first place. So that makes sense, but that's certainly not the situation here. Someone says in chat, Alt-X opens live clipping window on Twitch and it's working on your stream. Just try it. Yeah, the clipping is working, but not the posting of the clips to Twitch. So people are unable to post the clips in my chat. And I want to block hyperlinks as a general rule, so I don't want to turn that off. So I need to be able to whitelist the relevant URL so I can allow clips, and I don't know how to whitelist because the instructions that have been provided by various websites seem to provide me instructions that don't work, so I'm very confused. The mere appearance of subsequent prosecutions, even erroneous conviction of defendant. Yeah, was it also Georgia that held in the 60s that giving kids in juvenile court the same protections as adults would be hurting the children while convicting kid to much harsher? I believe that was Arizona who did that, or Arizona and New Mexico. Yeah, not Georgia on that one. So yeah, we don't need to give the child a jury. We don't need to give them a jury. We don't need to give them we don't need to give them a lawyer. Yeah, I'm pretty sure that was Arizona, not Georgia, but yeah. I don't in any way excuse the Georgia Supreme Court having 8 Republicans for this. I'm Republican, but I understand the law. The law is clear and manifest. So, do that. You post a link to enable clips in my chat. It might help. Let's see. You posted a link in my chat. You can't post a link in my chat. You can't post a link in my chat. That's the very problem. Links are banned. So you posted a link in my Twitch chat. No, you didn't. You can't. All right. And the court's analogy to a retrial following a hung jury makes some sense. Reaffirming a retrial. There's ways around the link ban. Okay, well, that's exciting. Thanks, Azeroth. Do you want to continue being a mod on Twitch? Maybe you should follow the rules that I set out. And yet, I can't quite shake the doubt that these points can be reconciled with the court's decision fully with the quite absolute sounding bar against retrialing a defendant who secured an acquittal verdict. Those doubts should be ringing pretty loud in your ear. This case is not like other cases where the verdict was void because the court lacked jurisdiction from the outset, because jeopardy did attach here, nor is it quite like a hung jury case, because there the jury doesn't return a verdict. So the court's conclusion here is that jeopardy did not end, and so we can be retried, depends on a state law legal fiction that treats the verdict as though it never happened. To be sure, the law can and must depend on legal fictions all the time, but this one bears a lot of weight, and I'm not confident it carries the court's decision over the absolute bar of retrying a defendant. He's saying all the right things. He's like, here's all the reasons I can't do what I'm doing, but I'm going to do it anyway. Indeed, the Attorney General acknowledges a retrial of a malice murder charge would be precluded from double jeopardy under law as it currently stands. This lingering doubt is not enough to justify dissent. But consider me dubitante. What is that word? What is that word? Hold on. Dubitante. What does that mean? Oh. Apparently is a special legal word. Okay. It's used in law reports of a judge who's doubtful about the legal proposition, but hesitant to declare it wrong. Okay. Cool. I didn't know there was a special word for that, but that's neat. Fun. Yeah. All right, cool. So that brings us to the end of the stream and yelling at the stupid. So yeah, we can now return back to trying to fix Twitch for those of you guys who want to help me since we're done with the stream. So if you want to log off because you don't want to help or listen to me fight a tech issue, you can feel free at this issue, but as long as you guys are here, we'll try to fix this issue. So let's see if we can figure it out together. How do I manage my own channel? Channel creator dashboard. Okay. You put it in plain text in chat. Okay. All right. Got it. Thanks. Let's see if this will help. Enable clips. How do I do this? That didn't do anything for me. It just took me back to my profile. Yeah, that link doesn't work. It just takes me back to my profile. Sorry. All right, so let's see. Got to be in creator dashboard somewhere. Where aren't links allowed? Because I don't want people dumping links into my chat. It's no more complicated than that. I don't want people just dumping links into my chat. They're banned on YouTube too. Because I want it to be that way. You have a Twitch help page, but not sure where to stick it. You can stick it. You need to have a bot to do the whitelisting. Why would you need to have a bot to do the whitelisting? That doesn't make sense. Why would a bot be able to do something I can't do myself? That doesn't really make sense. Manage stream. $81 subscribers on Twitch, by the way. Thank you. Why can I not manage my... I can't even get to where I need to be able to... I can't open my creator dashboard. It's not even letting me open my own creator dashboard. It's just giving me a generic stream, generic thing, and not letting me open my own creator dashboard. So I can't even...
Annie's bar. Step up. There are
You're making this very difficult for me, and I'm not liking it.
It's out.
Yeah, it won't even let me open my Creator dashboard. When I open Creator dashboard, it doesn't let me. It doesn't let me change any settings. Christ. All right, I'm going to give up. I'm going to give up. I did my best, but I can't make it work. I'm sorry. We'll try to figure it out. But we'll be on later tonight with Juicy Smollett. Juicy. And yeah, it looks like Twitch does his blame block and they don't have a whitelist. That's great. We'll figure it out. And so maybe we'll put Nightbot on there and figure it out from there or something. I don't know. I've been Uncivil Law. Until later, my friends, I hope all's well. Until later, my friends, cheers and goodbye.